Hi, I'm Debbie Moraes, and this is Legal Matters, the program designed to address the critical issues facing consumers and businesses today. It's legal information, practical solutions, and straight talk about a wide variety of topics, from finance and family law to Social Security, and recently technology, and more. Today, and perhaps the next session as well, we'll be covering issues that are relating to consumers. Special time. You better watch out applies in more ways than one. We'll get the help from our legal experts. It's gift-giving time, and there are probably at least as many buyer beware issues as there are great buys in the community. And many things that you just plain ought to know, from scams to outright fraud, lemon laws and cars, maybe a little bit on cyber gambling and cyberbullying. Stay tuned. So once again, our legal counsel from Audette, Bizarre, Cordero, and Grasso, in East Providence, Jackie Grasso and David Bizarre. You're going to be explaining what we need to know. But first, as we usually say, there are follow-up questions from previous segments. And this combines a little bit about privacy issues, which we've discussed, and also technology. It actually appeared in the newspaper. Here it is. Ready? Facebook photos lead to end of benefits. It was a story that came out of Quebec. A woman who was on a long-term sick leave for depression lost her insurance benefits because her insurance agent found photos of her on Facebook in which she appeared to be having a lot of fun. What happens? How can that happen?
Well, I guess first of all, let's just look at it in comparison to the law before technology, or as technology developed. Anything you do that's captured somewhere can always be used against you. Jackie and I are familiar with a case in workers' comp where a fellow's out on a disability from one job, but the insurance company knew he had a second job as a balloon delivery fellow, but maybe with a little striptease act when he was saying happy birthday. The insurance company called and asked him to make a delivery right to their office and asked if they could film it. That was used against him in court. In this situation, it's the same thing, except that technology has now allowed that woman to put herself out there and put evidence out. It's just evidence, though. And in that particular case, the pictures showing her having a good time while she's allegedly in a depressed state of mind is only evidence that maybe she is not as depressed as she is, but it's not proof in and of itself. They still have to prove their case to try to get her off of the benefits that she's receiving. So the whole point, and it's the point we ended with last time, is technology is a great thing, but you have to be careful with what you put out there because you are putting yourself out there to the world.
There's no expectation of privacy. When you join one of those social websites, networks, you have Facebook, MySpace, Linked Up, or whatever,
Right.
There's no expectation of privacy. So if somebody thinks they have their own particular page, even if they make it private, there's still, anybody can get into it.
There's always ways.
There's always a way to get into it. So you have no expectation of privacy at all when you put yourself out on the internet.
Would this individual or other single individuals who have uploaded one instance of them having a good time at a birthday party or whatever it was, would that qualify for her to say, I really still am in that depressed state, so what, I had one happy, healthy day?
I think what David said is right. It's merely evidence. It's not conclusory. So she definitely has the ability to rebut a presumption that, you know, she's no longer depressed. How do we know when the photo was taken? It could have been taken 14 years ago. Who took the photo? Where was she? Was it an isolated incident?
Right.
That would all be her defense.
And it goes beyond just that. You see, that type of case, disability policy, is really based on medical evidence. She can bring her doctor in, and the doctor might testify she is depressed. I want her doing things to try to help get her out of her depression. It doesn't mean she is out of her depression or that she's resolved her problems, and so his testimony is still going to be critical in that type of case.
Good to know. So for today's topic, I think in thinking about consumers, being in the advertising business for years, one topic that is always near and dear to every retailer's heart, when they're advertising, there is what's known as bait and switch. So, what can you do to explain it, and what can consumers really do about it?
Bait and switch is when you put out a particular product or you want to call it the drawer, or whatever you want to call it, something that appeals to the general public. I'm going to advertise for a mattress for $100. You go to the retail outlet, and in fact, the mattress for $100 is not available, but here we have a mattress for $300, or it's probably, the $100 mattress is probably as skinny as your pen here. So that's really a bait and switch. It's basically deceiving someone into thinking, I'm getting X, when in fact, the retailer is really pushing them towards Y.
And this, retailers, especially nationwide retailers, are sensitive to being careful about some of that. What they'll do many times, and you'll notice if you read the ad carefully, it may say while supplies last or limited quantity, and they use some of those products, what they might call as a loss leader. They're selling them maybe for even less than they pay for them to get people in the store. It's an advertising process that they use to get people in. They do try to protect themselves with while supplies last or whatever limiting language they might put into the ad. But if in fact, it can be proved that they had no intention of selling you what they were trying to sell you and that type of thing, a complaint can be lodged against the retailer.
If you think about the number of ads that people are bombarded with daily, many people will look at only the large print that says this percentage off or what the free offer is or whatever, and not read the fine print. But as long as that retailer has one of that item, or has ever sold one item at that low price, is he essentially safe because he could prove both?
I think it's a gray area. I mean, if he knows that he's only got 4 in stock and he's advertising in a public newspaper again, or back to the internet, how many thousands of people are reading the newspaper, how many thousands of people are on the internet? So there's a presumption that when you go there, they're going to have more than one item. Typically, if what David said is correct, while supplies last. If they have one, I think there's a good case of proving deception there, because they knew they had one at the time when they're representing that they had many.
I think there's some obligation for them to act in good faith.
Yep.
And if they are trying to get people in to buy something and they know there's going to be a massive demand for that, they have to have some reasonable quantity that might be looked at by the rest of the industry as what's reasonable under the circumstances. So they have to act in good faith.
Well, many retailers have various locations. It seems legitimate that the customer might ask them to look at other stores. Perhaps there is one. But on the other hand, suppose there is just an issue about we're out of stock and we won't give you a rain check. What do you do then? Do you have any recourse? Is that legit?
A lot of stores have different policies on that. Some stores will give rain checks on sale items, and it's it comes down to what's a good marketing technique, number one,
Yes.
and what is good business. And most stores that are legitimate stores, not fly-by-night operations, don't want to get their consumers mad at them. So they'll often allow you to have a rain check on an item if it's something that they're doing legitimately.
Mm-hmm. Ultimately, the buyer beware, the onus is always on, I guess, on the consumer. But at some point, if you think that someone has unfairly lowered the price this one time, or perhaps unfairly raised it and then lowered it to say that they're now offering their reduced price, is that something that's really worth a consumer pressing charges about?
I think if a consumer has an inkling that he or she is being treated unfairly or is not in good faith, I think you can always file a complaint. Rhode Island has a Consumer Affairs Division, Massachusetts does, you can always file a complaint. The Unfair Deceptive Trade Practices Act, that's part of that act.
Right, and that's the key.
Proving it.
If they are acting in a fashion, as Jackie says, that you can prove that they're acting deceptively or with some unfair practices, the Attorney General is charged with enforcing that statute and making sure they don't. And of course, there's always the Better Business Bureau that you could turn to.
Yes, and in fact, the Better Business Bureau also has the ability for you to file a report online, which theoretically takes only a few minutes. So if someone were inclined to do that, they certainly could. Of course, the best vote is when the consumer decides not to go back to that store, if that's the way
Right.
that business
What do
does
they say?
business.
If the old marketing cliche, so to speak,